Good evening, everyone, and welcome to this evening's School Inclusion Project meeting. And this evening, we're going to be talking about identifying cases for strategic litigation. If you're here in London in the room, congratulations on making it through the miserable, wet January weather. It's testing us all. It's a huge privilege to be here this evening. To be part of the School Inclusion Project, partly because I remember when it was just an idea, when we were thinking about what we could do as a chambers to address what is a societal issue of children being excluded from school, and then the issues that follow them. And what I see as a criminal practitioner is the strong correlation between those children who have been excluded from school, who lose the protective factor and protective feature of school, and then go on to enter the criminal justice system, and what that means for their life chances, and why it's so important that we offer support to those facing the process of school exclusion, particularly those from marginalised communities who may not be as equipped as others to advocate for themselves, because the process presupposes that you are able to advocate for yourself, and sadly we don't have legal aid to support those children, particularly from those marginalised communities. So the question this evening is, what does strategic litigation have to offer us if we want to use it in terms of addressing what we see as the injustices within school exclusion? I'm delighted that we have got an excellent panel joining us. We have Dr. Sharon Smith online, Olivia Hammond online, and shortly we're going to be joined in person by Aqsa Suleman, who is delayed, but she will be joining us shortly. And so I'm going to turn first to Dr. Sharon Smith, who is a parent carer of two young adults, one of whom has Down syndrome. And alongside that very important role in her life, she also is co-director of Special Needs Jungle and policy and parliamentary lead for the Down Syndrome Association. And so she very much works at the intersection of lived experience, legislation, and accountability. And so in addition to that, she has a PhD in education from the University of Birmingham. And her work is about challenging advocacy tokenism and driving participatory change to ensure disabled voices and families shape statutory guidance, policy consultations, and public discourse. So Sharon, thank you very much for joining us this evening. And you're going to be talking about inclusion in name, exclusion in practice, send reform before the school's white paper, I believe.
Yes, that's right. Thank you so much. I'm absolutely delighted to be joining you this evening. And I would like to thank Ollie in particular for inviting me to come and speak to you. You've taken away my introduction. That's great. I don't need to say that. So hopefully I've got a little bit of extra time. I think what's important to say in all of the roles that you mentioned is that I'm particularly interested in policy related to inclusion for children and young people who have learning disabilities. That's my key sort of area of focus, and that's what's sort of driven me to come and talk today about the area I'm going to be talking about. So I want to explore and get your views on what I see as a rapidly expanding area within our current SEND system. One that is spanning both compulsory school age, but also the post-16 landscape, and I will take these in turn. I had intended to focus my talk today on the changes that are taking place in schools in advance of the school's white paper, and I will talk about that. But the more I think about it, and the more I've been sort of preparing and looking at the landscape, I'm actually finding myself more and more drawn to the post-16 landscape, and what does inclusion mean for learners who have learning disabilities within further education. And I'm wondering whether there might be actually greater scope potentially for some legal challenge in that space. So starting with the schools phase, what we're seeing at the moment, and as I say, this is in advance of the schools white paper, which we're obviously all still waiting for, is that local authorities and multi-academy trusts and also other schools are rapidly expanding resource provisions, inclusion hubs, nurture bases, satellite units, and other hybrid models where there is a specialist place or space within a mainstream setting. And they often have soft, reassuring names such as Rainbow Room or the Sunshine Room or a Nurture Nook or an Inclusion Pod. And these are also featuring in lots and lots of the ministers and the Department for Education's current conversations that are shaping the schools white paper, but also lots of their little sort of PR videos. In fact, I was just watching one with Bridget Phillipson before I joined this session, where she was talking to somebody about a pod in the school and how she was envisaging that as great practice for inclusion. Now, as I've said, this expansion is happening in advance of this long-awaited schools white paper. So the system is actually reshaping itself or being reshaped before there's any national policy direction, before MPs have had an opportunity to vote on this, and before there is any changes either in the Children and Families Act legislation or any other statutory framework. These hubs are being presented as innovative, inclusive, but they appear to have no statutory definition or statutory guidance. There's no clear evidence base. There is a limited amount of evidence in terms of research about what is or isn't effective in these spaces, but there is no rollout of that in any form of statutory guidance. And there's no firm legal footing, as far as I'm aware. So I think from a legal perspective, they're raising lots of fundamental questions about what is inclusion and what is inclusion within mainstream schools. So, as I've said, as far as I know, there's no statutory definition of a resource provision, a hub, a pod, a rainbow room, or a base. I don't believe they appear in primary legislation or secondary legislation. And as I've said, there's no statutory guidance. There's also questions about where they sit in an EHCP. And again, we know that there is a wide range of what's happening out there. So is it special education provision, in which case it should be in section F and be specified and detailed and enforceable? Or is it a placement? Is it a separate placement? Which case it should be in section I, and then there should be an option for parents to either choose that placement for their child or a young person to choose it, or to say that they don't actually want their child to be in that place. But what's happening in practice is local authorities, multi-academy trusts are actually treating them almost as a third category, a placement that can be used without necessarily naming it as a placement within an EHCP and without specifying exactly what that provision looks like for a child. Also, there's a lack of accountability at the moment. We know anecdotally through our work at Special Needs Jungle that multi-academy trusts in particular are moving children from mainstream classrooms to hubs, maybe from hubs to alternative provision, back to mainstream, or maybe even completely outside of the trust. Often this is without parental consent and sometimes without parental knowledge. Certainly without an EHCP review and local authority decision making. So there is a clear development that's happening already of a separate specialist system that's existing within mainstream education settings. And I'd say that this is expanding faster than the law that potentially will govern it. So I'd really value your thoughts on that. But actually, my interest as well is about post 16. And I would say this is a place where inclusion quietly disappears for young people who have learning disabilities. And we have personal experience of this for my daughter for the last 5 years. And I think it's an area where maybe some of those legal questions become even sharper, because this isn't something that's just emerging, but it's something that's already deeply embedded. So for young people who have learning disabilities, inclusive education, as we would broadly understand it, effectively ends at the age of 16, at the end of compulsory schooling. They're often funneled into foundation learning or life skills or pathways to independence, often in completely separate buildings and spaces on further education campuses. The curriculum offer will be strikingly narrow, with life skills, animal care, health and social care, or performing arts likely to be what's on offer. Now, those subjects obviously in themselves are not inherently problematic, but they become problematic when it's the only option that is available, and also when they're being delivered in completely segregated spaces on that further education campus. So we have a situation where a young person might have a learning disability, but be particularly talented in an area or have an area that they want to develop their interest, but they're prevented from doing so. So, for example, as I said, we have lived experience of this. My daughter gained a grade 5 GCSE art and design, and she did really well in that qualification, but didn't secure any other GCSEs. So she has been unable to access any courses in further education, such as BTEC courses. The only thing she has been able to do is to be on life skills and animal care courses. So I think my question here is, well, what does inclusion look like in further education for learners who have learning disabilities? Is it enough to say the college is inclusive because SEND learners are on the same site, yet the young person is only taught with other disabled learners, have no access to engaging with mainstream peers, no access to mainstream courses? They're in a separate building and they're following a curriculum that has only been designed for learning disabled learners. And I would argue that physical proximity is not inclusion, and that what we're seeing here is basically segregation and a separate education, but on a mainstream campus. So I think we have this parallel SEND system, one that's not necessarily grounded in evidence, not grounded in rights, and certainly not grounded in inclusion and inclusive principles. We've got schools, hubs, resource provisions expanding without a statutory footing, without statutory guidance. And in further education, we have got well-established segregated pathways for young people who have learning disabilities as default. So whilst the law technically supports inclusive education for people who have learning disabilities up to the age of 25 if they have an EHCP, it's not necessarily structurally possible with the way that our further education system is set up. That's the funding mechanisms, the curriculum models, the staffing structures, the commissioning, etc., meaning genuine inclusion is almost impossible for colleges to deliver. So my question is not necessarily does the law allow inclusion, but do our current structures, particularly in further education, make inclusion impossible in practice for young people who have learning disabilities? And if so, what does that mean for their legal right to an inclusive education? And so I'm not a legal expert. I'm aware that there's lots of people here who've got lots of legal expertise. And I just wanted to bring this to you to suggest that maybe this is an area where there's a possibility for some legal challenge. And I'd like to thank you all for listening. Thank you.
Well, thank you, Sharon, so much. There are quite a few questions that we can pick up in a discussion. I think probably what's best is to hear all of the speakers and then we can go to questions. I'm looking at the room. Does anybody have any?
I don't know if we forget.
Okay, we might forget, Olivia is suggesting. If anybody online has a question, we have a Q&A function, so you can feed in your questions that way. So the final question that you posed, Sharon, was, do our current structures make inclusive education possible or impossible, whichever way you frame it? I guess the question really for the lawyers in the room is, does that lend itself to a legal challenge? And whether there's anybody who'd like to pick up on that. And luckily, Ollie is ready and waiting and primed to answer.
I think tricky, but there are a few different ways of looking at it. So what is the driver behind this de facto segregation? Is it money? Or is it a lack of understanding And if public authorities at different levels, be that central government level down to, is it an issue where we need a public authority to turn their mind to the issue more? So is it an issue at central government level, Secretary of State, lack of statutory guidance, lack of any form of sort of oversight and understanding of what's happening on the ground? Or is it could you look at it at a school by school level, or a local authority by local authority level, at what is driving the sort of practices? Obviously, it's a widespread practice, so it's not isolated to an individual school. Going after local authorities is somewhat tricky given the academisation of lots of these of places doing this. So it may be that there's a multi-academy trust with a particularly bad practice that could be worth looking at in particular, if they're effectively having a sort of segregationist approach without really thinking through actually how it's operating on the ground and how it's impacting the children. The most obvious tools to have a look at it, I suspect, could potentially be the public sector equality duty under section 149 of the Equality Act, which the purpose of that is for the body exercising public functions to go through the procedural steps of turning their mind to whether there's discrimination in what's happening. So it's a duty to foster good relations, promote equality of opportunity and eliminate discrimination. And they really need to understand as a prior question what's happening on the ground and why that's happening. So it may be that there is a public sector equality duty issue. It's a limited sort of basis of challenge, but it could potentially be, hang on, there is an obvious discriminatory impact here in that disabled children are being sent, they're physically in a site, but there's a cohort that is not getting a fully inclusive education. It may be that it also impacts on other protected characteristics too, the intersection of race and disability, for example, if there's a disproportionality there. And if, for example, a multi-academy trust isn't focusing their mind on it, that could be a problem. Use of isolation rooms for disciplinary reasons there's recognition at statutory guidance level that there should be monitoring of how that's used based on protected characteristic. It seems to me that there may be an argument also for monitoring how broad the curriculum is based on protected characteristic, for example, or type of education being received based on protected characteristic, because that's about promoting equality of opportunity. Is the most relevant limb of the public sector equality duty there, probably. And it seems to instinctively like there's a not proper consideration of how they're promoting equality of opportunity by not actually making sure that inclusive education is working well in practice. So that could be a potential way in, maybe.
So public sector equality duty, and Dan, you had your hand up. Dan Rosenberg.
Yeah, I was going to say that it needs to be looked at, I think, a lot at the multi-academy trust level, particularly if the multi-academy trusts have their own alternative provision. Because once you've got your own alternative provision and you've invested in that, you've got to fill that up. And there's a question as to who you fill that up with, which is generally a certain cohort of the pupils. So I think it's not so much a local authority thing, because the local authorities don't control the schools, the local authorities don't make the decisions. The decisions as to who gets pushed out, in just looking at the alternative provision side of things, that's MAT level, and it's done, or at least in what I've seen amongst the MATs who have their own provision, it's done fairly wholesale. You know, there is the provision, it's filled up. You know, this always used to happen with sometimes schools would block buy places. So, like many years ago, with the case, the school had block bought 12 places at a college. It therefore needed to find 12 pupils to ship out. So I think it's the way that it's structurally set up. Once you've got that set up, it follows.
Becomes a driver.
Yeah.
Is there anything at does anybody think there's anything at a national level, at a statutory level, that could compel the provision of a wider, more diverse post-16 curriculum? Because that is part of the issue here, is that there's no requirement to have a wider, could be an issue. I'm not getting a receptive response.
I think it's tricky without an amendment to primary legislation to force that to happen.
Yeah.
But it's become a default of not happening. And I mean, there's a period of SEND reform happening now, and there's going to be primary legislation. It's probably an advocacy issue when that legislation is going through. Try and get that up the agenda is realistically the more effective way of doing it, I suspect. But if you had an individual case where there were potentially quite extreme facts of basically no options available, you could potentially bring a challenge in relation to a specific decision. Like if you try to find every possible option locally, that could, I mean, it'd be a really difficult challenge, I suspect. But especially if you have an EHCP in place and you manage to get content in section F that would require and findings in relation and findings more generally in section B and F, and there were expert reports supporting the need for inclusive education, and I think you may have some arguments that the local authority weren't doing enough to secure special educational provision if the type of special educational provision they required effectively required a broader curriculum by default. That might be a way in, but you'd have to look at the individual facts of it. I think tricky, unfortunately. I think the sort of other issue around alternative provision site, I think is ripe for challenge. And something could and should be done, particularly, as Dan said, about multi-academy trusts, which are basically just piling them full, and there aren't attendant safeguards to how they do that, without review of actually whether they're getting meaningful, full-time, suitable education. It's just because the duties are a bit weaker post-16, and because it's a sort of combination of different failures that you're trying to address in terms of lack of options available post-16. I think the challenge is harder, and it's more of a policy reform.
So there may be an opportunity in the forthcoming, in response to the forthcoming white paper, to look at this as a policy issue. Just picking up on the responses online, Stephanie Harrison, KC, has echoed what has been said by Ollie, that the public sector equality duty in Section 149 of the Equality Act 2010, particularly the positive duties, as well as the anticipatory duties under Section 20 and Section 29, may be an avenue for challenge. And then Deanna Spillitz, I hope I've pronounced your name correctly, refers to SRP bases and having different remits on the SRP mainstream split. For example, one has a policy that all pupils must be able to access mainstream for 50% of the academic day, another that it is a 75% split with the pupils spending 75% in SRP/ARP. So who identifies this remit for that particular split, and can the public sector equality duty challenge the process on how this was determined. I think that's something to think about and reflect upon, and it's a really helpful contribution. Thank you very much, Deanna. And so I'm now going to turn to our next speaker, who is also joining us online, and it's Olivia Hammond. She's a community advocacy caseworker for the Traveller movement. Olivia is a Romani Gypsy woman with over 7 years' experience in the education sector, and she now supports Romani Gypsy, Roma and Irish Traveller community members to engage with schools to achieve the best outcomes for their children. So we're delighted to have you here today, Olivia, and you're going to be talking particularly about the exclusionary practices faced by Romani Gypsy, Roma and Irish Traveller children. So thank you very much, Olivia, for joining us.
Thank you for having me. It's brilliant to be here and to speak today. Again, yeah, introduction done really, so I'll jump straight in. I was asked to sort of speak about things that we've been seeing on the ground recently. I handle all of our education casework at the Traveller movement, so I see everything that comes through. And I thought it would be good to start off with a case study that really shows what sort of discrimination is happening in schools. And there'll be people here today that have really mixed levels of experience with supporting Romani Gypsy, Roma and Irish Traveller community members. Some will be super experienced, some won't have really come across it before. So I think this case study really shows the things that are happening in schools. So I'm going to start off with that. This is a case study by a young Romani Gypsy person that was shared with us. So a few years ago, the primary school that myself and the other Romani Gypsies in the area all went to was closed down. We all moved to another school in the area as a group. I was in my last year, so only attended for around 9 months, but there was always Romani Gypsies in that school moving forwards. There hadn't been Romani Gypsies in the school before, and I don't think the head teacher knew anything about our way of life, culture and traditions. Upon entering the school, we all felt eyes on us and a real nervous energy from the teachers. I began settling into the new school and got used to the stricter nature of this environment compared to my old school, who celebrated Gypsy culture and had huge displays up in the corridor about our language, Rumness, and encouraged us to talk about our way of life. Little by little, though, we all began to experience negative interactions with teachers, and specifically the head teacher. It began by us all being pulled into a classroom where we were told that we could no longer speak in Rumness during school time, as no one else could understand it. However, we spoke in English 99% of the time and only used the odd word to each other. This was extremely difficult for lots of the students, as they used the words constantly and found it almost impossible to erase words from their language. If students failed to stop using Rumness, there would be repercussions, such as being asked to leave the classroom for 5 to 10 minutes. The next thing to happen was being told that we couldn't sit together at lunchtime. All Gypsies were split up and one was allocated per table. Again, this was very difficult as people were ripped out of their friendship groups and were scared to be seen talking to close friends and cousins. I'd also add that there were absolutely no negative incidents in the lunch hall prior to this change. It had just been noted that other students felt intimidated by the group sitting together. A week later, we were forbidden to play together at break time. We were monitored by extra staff walking around the playground. Half of the children ended up sitting alone at opposite ends of the playground as peers wouldn't allow them to play with them or talk to them. There were serious amounts of bullying that never got addressed. None of the children were awarded certificates ever, even though some were thriving in lessons. And children were never allowed to carry out classroom responsibilities such as taking the register to reception. Overall, it was a humiliating couple of years. Children withdrew and even developed phobias of eating after being put into really uncomfortable positions in the lunch hall. So I think that really showcases the things that are happening in schools and are still happening. And all of these little things create such a hostile environment that parents end up removing their children from schools to home educate because they're just facing another barrier every single day. I recently supported a Romani Gypsy mother who had 2 sons in primary school and a daughter in the nursery that was attached to the primary school. She really liked the primary school. The boys had settled in there well. Her daughter loved the nursery there, and however, there was these issues that kept arising. So, grandmother went to pick up the boys from school one day, and upon going to the playground to pick him up, the oldest one, school teachers just said that they didn't know where he was. She obviously started to panic. Where is he? Called his mother to come to the school. Teachers were sort of running around. They went to reception. No one knew where this child was. Apparently, he hadn't been seen since 2 p.m. that day. It took around half an hour for them to determine that a teacher had taken him to another school to take part in a sports competition, which would have been fine. However, there was never any consent given by the mother to actually take him to this other school. She didn't know where her son was. During this half an hour of not knowing where her son was, all sorts was going through her mind. Had he been taken? Had he ran away? Had he come to some sort of harm? You know, he was only 7. And had sort of sank to the floor, been crying, you know, obviously quite emotional. She thought her son had been taken. After this, teachers at the school then banned mother from being on school grounds, said she'd been extremely irate and aggressive. She hadn't been. She'd just been really, really distressed and emotional, as you would be if you thought your child had gone missing. So yes, she was banned from school grounds, so was Dad. So there was no one that could actually take the kids to school because they weren't allowed on school grounds. So she had no choice but to remove them from school and begin home educating. Now, obviously, none of this should have happened in the first place. She didn't know a child had been taken to another school for this competition. And then, because of that reaction, was then banned from school grounds. So it's just things like this that we're seeing all the time. We have also seen issues around the change of the T code recently. Now parents are being asked to provide really clear evidence that they are away working. So when families are travelling for work purposes, previously schools were quite happy to accept that usually, whereas now schools are asking for evidence, and when parents are asking what evidence they need to provide, we've seen several cases where schools can't actually tell them what evidence they need. They just sort of say, we need you to provide evidence that you are away working. Which obviously is quite difficult because then parents are getting fined because it's not registered that they are away working because this evidence hasn't been provided. So that's an issue that we've been seeing recently. We're also seeing lots of parents just really concerned about sending their children to school, worrying for their safety. And when you're hearing these stories about children being taken off school grounds without parents' permission, and that sort of thing, you know, you can start to see why. So that's been a real issue, and parents are really concerned for their children's safety. And then there's been other issues. I recently supported a Irish Traveller mother who has a child in primary school who has special educational needs, and the child had always been really well supported by the school. They were happy to sort of meet with the mother, support in any way. The child had issues around eating, and the only thing that she would eat was sort of a microwaved sausage roll. And every single day, the teacher would take 30 seconds, go to the staff room, heat it up for her, and she would eat her lunch, no problem. And then a new head teacher came into play and said this wouldn't be happening anymore. It wasn't fair on the teacher's personal lunchtime, even though the teacher had sort of been really quite upset about it and expressed to the mother that she was more than happy to do this. You know, it was 30 seconds out of her time. But the head teacher said, absolutely not, you can't be doing that. Then all teachers were told to stop meeting with her, to stop speaking with her in the playground. She also had reading issues, so if she ever received a letter or an email, she'd take it with her to the playground when she was picking up her child, and the teacher would read it to her, talk to her about it. That all stopped. No one was allowed to read out the letters to her. Till in the end, she didn't really know what was going on with schools. You know, if there was a school trip, she wouldn't be aware because no one would call and tell her. It was just a letter that she was unable to read, until she felt that there was no choice but to begin home educating her child because she wasn't able to communicate with the school. They weren't catering for her child's needs anymore when it hadn't been a problem up till now. And she was really quite distressed. She wanted formal education for a child. She loved the primary school. Everything had been fine up until this point. The child was sort of 8 years old, had been in that school all of her life, and then things drastically changed. So yeah, those are sort of the issues that we're seeing. There's so many more. I could be here all day. But yeah, that's sort of some case studies that I've been supporting on recently, some cases that have been coming through. And I suppose it just sort of raises the question really of what can legal professionals do to enforce equality, human rights laws, because there's so many people struggling and don't really know where to turn. How can we make it more accessible for them to speak to someone? So yeah, I'll stop there. I'll hand back over.
Thank you so much, Olivia. You've shared some very profound case studies there, and they certainly are quite difficult to hear in terms of the way in which communities are being treated in this way. Sharon has just shared that it's important to give the voice to these stories and ensure that they are told. Does anybody want to answer Olivia's question, which is how can legal professionals help? Yes.
I'm not a lawyer, so my name is Ian Wixton, but I'm an education consultant with a particular interest in mitigating NEETs. And this is an anecdotal point, but both the previous speakers are talking about situations where the prevailing wind, if you like, is towards exclusion. And I was lucky enough over the winter to meet a head teacher from Adelaide. We happened to be in the Perth Test match together briefly. And his claim to fame was that in 37 years as a head, which is quite a long record, in inner city Adelaide, he had never excluded a single pupil. And it was his predisposition to include where possible on the basis that the child would always be much better off. And I just offer that as a sort of another side to the culture that was prevailing there, as opposed to the culture that I'm hearing about from the last two speakers.
Yes, well, thank you for sharing that. And I think there is what was one of the themes of Olivia's case studies was the culture that was being driven from the leadership. So the first case study was about a group of children who moved from one school that was clearly very inclusive and that had taken a number of steps to make the community feel respected, feel valued. Their culture was shared within the school with displays and other ways in which it was recognised, and then going to another school where the prevailing attitude from that head teacher was very much wanting that distinct community and identity to sort of be erased, really, and the children to adopt a different way of being, which didn't allow them to celebrate their heritage. And again, in the last example, again, it was a change in head teacher that saw the exclusionary practice. So how can we, thank you for sharing that, how can we as lawyers support this community? Particularly, we see this community as one which is the highest in the statistics in terms of minoritization in many spheres of the way in which public duties are exercised. But in terms of education, what might we be able to do to support these communities, and particularly thinking about the case studies that have been shared? Does anybody in the room want to start? Yes.
I think one of the problems with this is when you were telling as about the case studies, there was like audible gasps and shaking of heads because they're such obvious and horrifying things that the law should be able to rectify. It's not a case of strategic litigation, it's something more intractable, which is just capacity within the community, the legal community, but also it is one of education as well. Despite the fact it's a group of people who are so overrepresented in exclusion statistics and clearly who have such difficult experiences in school and face discrimination in school, I do think it remains one where public education of the reasons why that's happening is still quite low. Even in the legal community, and I speak for myself as well there, I mean, that's why talks like this are so important. That doesn't help increase capacity, but at least it would help lawyers to be able to quickly identify what the issues are in cases concerning these groups of young people, and be able to potentially litigate them more effectively and more efficiently, and be less scared of taking them, if that makes sense, more confident to take them, more outraged when they see them and use that anger as a driving factor. I think that's the only point I can contribute. Otherwise, I mean, the thing about capacity is obviously something we talk about a lot and with no obvious solution to, and that's the problem is it's just such obvious wrongs that we need boots on the ground to be able to remedy.
Yeah, so when we talk about capacity, we're talking about the numbers of available lawyers to take on these cases and the lack of availability of funding to support them. But I think I've got a really poor track record of advocating for legal guide in these areas, but I know that already the work of the Traveller movement will already have some really good information and resources available, but perhaps it's about getting it to lawyers and getting it into getting it disseminated more effectively, because it's important. Well, it's important for lawyers to feel confident to take on these cases, but I guess it's also important for lawyers to communicate to these communities, to the traveller community more broadly, that we are going to advocate strongly for them. And so it is about us also signalling our inclusivity. But is there do you think there is any space for us exploring any strategic litigation, or do you think it's just a matter of communicating to these? I mean, they're lucky because they've got Olivia advocating for them, but is there anything more we can do to support? Yes, Ollie. Just to say, that was Alex Temple, who is another barrister for Chambers, and now this is Ollie Percy for those of you online.
I completely agree with Alex about the individual enforcement point. There's a massive problem with legal aid funding for discrimination claims and the cost benefit criterion being satisfied for individual county court claims. And then county court claims take months and months and months for anything to ever happen, and query whether that's an effective remedy versus disability discrimination claims in the first tier tribunal can often be, if you get into the fast track process, no court fees, much faster. I think there may be something, I don't want to say there's nothing that can be done about obvious direct discrimination in schools of separating kids out in a way that's obviously disgraceful. And on a case-by-case basis, there might be a group of children that could come together, and maybe a county court group claim could work in those circumstances. But the T code is potentially something that may be riper for a challenge, because under Article 8 of the Convention, it's well established that the state has positive obligations to facilitate a nomadic life of travellers. And it seems to me that the T code and the evidential requirements required represent a practical barrier to that nomadic way of life. If you have to provide extensive evidence of work, and then also the threat of penalties for not being, prosecution for not being in school, the combination of the two, if you had enough evidence of that being a practical barrier to families actually being able to exercise, they're sort of called the pincer movement of nomadic way of life and access to education not being fulfilled if they're being subject to penalties or prosecution. I think there could be something there to try and stimulate a review of the T code as not working. both on an Article 8 basis and also potentially on a public sector equality duty basis, the need to undertake a review of that. So I think T code, probably the right issue for any strategic litigation, but would require really careful evidence gathering. And there are some funders that potentially could fund some discrete work to gather that evidence about the extent of impact. And the case studies that you've mentioned are really shocking and could potentially feed into that. So I think that'd be something really interesting to follow up on, because T-code amendments, I think, are 18 months old or something like that now. And you can have some evidence of how that's operating or not operating effectively.
Ellie Costello from SquarePeg has messaged to indicate that, to share that SquarePeg is working to decriminalise school attendance and reduce coercive coding and discrimination. So it may be that they're offering to collaborate with the Traveller movement with a legal challenge. So in terms of looking at fines and prosecutions, which are neither in the families or the public interest. But and then Stephanie Harrison has said that it's flagrantly race discriminatory and a breach of the Human Rights Act, and so it may be that there could be a civil claim as a group. So it sounds like there's an opportunity that we can link up SquarePeg with Olivia and the Traveller movement, and Stephanie Harrison has clearly put her hat in the ring to be part of that legal challenge. So thank you, Steph. But also, I think, yes, it's really important to also think, Ollie's mentioned taking cases to the first tier tribunal. I also just, as a mediator, if you want quicker resolution, you can also, once you've triggered litigation, you can also seek alternative dispute resolution. And what you find with mediation is you can sometimes reach a quicker resolution. So you don't have to wait to get to court. You've got the parties engaged in the real issues, and therefore you might be able to reach a mediated resolution and get children back into education quicker. So just bear that in mind. But that's certainly an avenue to explore. And Ellie Costello has come back from SquarePeg to say, given the Children's Wellbeing in School Bill has increased powers for school attendance orders, is there a preemptive challenge that's possible based on equality duties? It seems to me that would be a really valuable challenge to prevent those powers being widened, specifically when they're being used against this group in a potentially discriminatory way. And as Ollie says, Article 8 specifically protects the nomadic lifestyle of travellers. So we should be ensuring that we are preemptively taking litigation in this area. This seems to be an opportunity. So we will make sure, as the School Inclusion Project within Chambers, that we loop in all of those individuals, Olivia with Ellie Costello and SquarePeg and Stephanie Harrison. But if there's anybody else who's interested in being involved in what might become a group litigation, then please do either message us on the chat, get in touch afterwards, or come and chat to us afterwards, and we can make sure everybody's in contact with one another. I think that's all on this topic, unless anybody in the room wanted to bring up any other questions. And now we're going to turn to our final speaker, Aqsa Suleman, who is here. She's arrived. She's going to be invited to come and sit next to me. I hope it's not too daunting. And while Aqsa finds her feet, she has got a presentation, so we might. I'll share it. Okay, thank you very much. Aqsa is here from the Runnymede Trust, and her role there is to coordinate the APPG for race and community. She works as well with the wider policy team to generate knowledge, publicise the demands being raised by that APPG, and strengthen awareness and action around policy priorities across education, migration and stakeholder engagement. So we're really delighted to have Aqsa here, and she's going to talk about child criminal exploitation and school exclusions. What more? Thank you.
Thank you very much, Kate. Thank you very much, everybody. You can move on to the next slide, Sophie. So when it comes to school exclusions, they are disproportionately affecting, I think, in the current climate, children who are at risk or known to be associated with child criminal exploitation. And the process that usually happens when it comes to child criminal exploitation within schools is very reactive, and it's very much subjective as well. When CCE is identified, the initial trigger is often behavioural concerns being raised at school level or safeguarding concerns within the school. The school may use internal safeguarding logs like CPOMs to record their initial concerns. In practice, once a child has accumulated a certain level of incidents or concerns, that can typically lead to a referral to the multi-agency safeguarding hub. And there is, once that has been received, there is a communication with the local authority, who then has the statutory duty to undertake a child in need assessment or child protection plan assessment, consider the risk of extrafamilial harm that child is facing. And depending on the degree of risk identified, that child can be subject to a formal child in need plan or child protection plan. And when such a plan is issued by the local authority, that requires a multi-agency approach. So that child would have access to a network of a social worker, youth justice services, the school, who are invited to meetings on a quarterly basis to discuss that child's needs or the risk that the child is under, and how to mitigate that in terms of any interventions or actions that are being taken at school level or more widely by the local authority. However, when it comes to children at risk of exploitation who are victims of exploitation, usually a MASH referral is made in tandem with a disciplinary decision like a suspension or a school exclusion. So usually the process is occurring alongside the child being taken out of mainstream education and being displaced out of a protective environment like a school, which would have a head of year, which would have a safeguarding lead or a SENCO to support that child with a series of internal interventions as well. And that's where a lot of problems arise. If a child is excluded from school, but there is a level of awareness that that child is a victim of exploitation, what needs to happen to secure better support for that child, to A, protect the quality of their education, but B, mitigate the risk of further exploitation. If they're out of school premises, they're more likely to encounter those who are exploiting them, and it could worsen the degree of harm that they are facing as victims. So that's something that needs to be considered more fully in litigation, in our approach to working with children who are facing these circumstances. If you could move to the next page, Sophie, thank you so much. School duties and limitations. So there is a child exploitation disruption toolkit that the Home Office has published, and that does outline safeguarding expectations for various bodies, including schools. However, when it comes to issuing something like a national referral mechanism, schools are not designated first responders for the purposes of the NRM. That responsibility sits squarely with your local authority, with the police, or with authorised voluntary sector organisations. Schools would primarily contribute through pastoral safeguarding routes or behavioural routes. So if they're not issuing a suspension or an off-site direction or a permanent exclusion, you'd expect them to initiate mentoring programs or pastoral interventions. So a lot of schools in London have a partnership with Football Beyond Borders. So they would perhaps issue that intervention for a child who's known to be at risk of CCE. And whilst there is a series of internal pastoral interventions, unfortunately, there is not enough specialist understanding of CCE within the school level, meaning that signs of exploitation aren't really fully realised until the level of risk has escalated and until that child is known to have serious behavioural concerns and they are not only being exploited but at serious risk of exclusion or in the process of being excluded. And because of this, the common sequence is very subjective and reactive at school level. So a child may exhibit some symptoms or indicators of exploitation. The child will then be initiated to a meeting with their DSL or meetings with other teachers. Then you might have a MASH referral made by the school. Then the child may experience further disciplinary action, such as a suspension or a school exclusion. And only then, once a MASH referral has been initiated, there is this lengthy process of then issuing a plan, not issuing a plan, and then more professionals may be involved. And it is at the maybe later stage or tail end stage when an NRM referral may be made. The local authority may choose to make an NRM referral after they've already initiated their child in need assessment or a child protection plan. And because it's made at quite a belated stage, it could mean that there has been a greater level of risk and harm that young person has been exposed to as a result. So what is an NRM? If we go on to the next slide, thank you so much. What is the NRM? Well, this is a statutory framework that was initially set up to kind of address migration concerns, to identify potential victims of modern slavery and human trafficking and ensure that they could access appropriate support. And I think it was about maybe 2014-15 time, that's when Surrey county lines got brought into this statutory framework. And it was used as a tool to support potential victims under the age of 18, where there is reasonable cause to believe that they may be at risk or victims of child criminal exploitation. And an NRM referral is usually made without the consent of that child, on the basis that safeguarding takes precedence over consent. And at the time in which an NRM referral is made, usually there should be a referral from the local authority to the Independent Child Trafficking Guardian Service, and they provide independent advocacy and support across criminal justice, across immigration processes, across safeguarding as well. However, in terms of capacity, over 2/3 of local authorities currently have access to this service, but not all local authorities have access to this advocacy service. The NRM also enables certain agencies, including NCA and the Modern Slavery and Human Trafficking Unit, to collect and analyse data on a regular basis on the nature and scale of modern slavery in the UK, and all referrals are made through a national online system with information that is shared more widely across police forces, schools, central government bodies and local authorities as well. As I mentioned to you before, going on to the next slide, there is at the moment a limitation on who can make that NRM referral. Schools aren't designated first responders, so would not be expected to make that referral, and the onus is usually on the local authority. However, on average, it takes about more than 400 days to get a decision when it comes to an NRM referral. And as a result, the Home Office, to address these significant delays, has implemented a pilot programme, a decision-making pilot programme in partnership with local authorities to shift the decision-making onto the local authorities. Usually, NRM decisions are made centrally by the single competent authority located in the Home Office. And this pilot is supposed to test whether it would be more effective in having these decisions devolved and made more locally within existing multi-agency safeguarding structures by professionals who are directly involved in the child's care. And when it comes to this particular pilot, it was recently expanded in April of 2025, and more partner sites have joined. In summer 2025, we had partner sites join across Birmingham, the London Borough of Southwark joined. There was also some other boroughs across London and also based in Wales and Scotland as well. And within pilot areas, reasonable grounds and conclusive grounds decisions will be now made through a local multi-agency panel rather than by the SCA. So that panel will be comprised of 3 statutory safeguarding partners, the local authority, police and health authorities. Each partner would provide 1 trained voting decision maker. And whilst the social worker can be involved, to avoid conflicts of interest, the allocated social worker that child has won't chair the panel or won't be involved in the decision making per se. But the independent child trafficking guardian service, that person can be consulted and invited to contribute to the rationale behind the decision, but they don't have voting authority on panels of this nature. And it is time capped, so a reasonable grounds decision needs to be made within 45 days of referral to the pilot site. Where evidence allows, a conclusive grounds decision needs to be made in the same meeting. Otherwise, there needs to be a second meeting that takes place within a maximum of 90 days. And whilst this process of decision making is going on, the child is expected to receive ongoing safeguarding support, regardless of what the decision may be. So whilst there is an attempt to devolve decision making and to reduce the delays faced by children when it comes to this referral being made, it's still within the remit of the SCA to review and be notified of reasonable and conclusive grounds outcomes. To provide data, there needs to be data sent by the local authority to the SCA on all outcomes in relation to NRMs. And there is a quality assurance process that takes place between that local authority and the SCA as well. So they are handing over a few elements of their power, but not all of their power. And pilot sites that have been tested, I believe there was a briefing by the Youth Justice Legal Centre that was published in October of 2025, and it said that in pilot sites where this was already being delivered, the delay had been reduced from 400 days to 100 days. So it's still not meeting the threshold as stipulated of 45 days or 90 days. There's still a bit of a delay in getting that decision. So what does the referrals data show? Sorry, could you move on to the next slide, please? Thank you so much. So what does the referrals data show? It shows that when it comes to children and young people, 50% of all child referrals to NRM involve UK nationals. The majority are victims of county lines exploitation. And this is situations where children are being groomed or coerced into transporting drugs or money for organised criminal networks. The NRM data demonstrates the scale of the issue and the dominance of referrals being made as well, and who is the party making those referrals. So in 2024, county lines referrals accounted for 10% of all NRM referrals. And there has been a little drop in 2025, where 7% of all referrals in July and September 2025 were county line referrals, and that was down from 9% in the previous quarter. And when it comes to who are the referrals made towards, 76% of county line referrals concern male children. And who are the people making the referrals? Predominantly, it is local authority who have the discretion or who have that accessibility to make referrals. 19% of referrals in 2024 were made by them, followed by 15% from police forces and regional organised crime units. And the lowest is NGOs and third sector organisations, standing at 4%. And this goes to show that safeguarding through the NRM is overwhelmingly driven by particular institutions, the police and local authorities, rather than perhaps community-led organisations or more trust-based organisations for that child. And moving on, the NRM is not a neutral safeguarding tool. So if we move on to the next slide, Sophie, thank you so much. It does have a disproportionate impact predominantly on marginalised children and children of colour. And there was some research done by a researcher based in the University of Oxford, and the publication was called The Hidden Harms of the NRM. And it demonstrated that frequently NRMs operate as an extension of racialised criminal justice control, particularly for UK-born children who are facing county lines exploitation. And a lot of the children who were interviewed as part of this research spoke about the lack of agency, the lack of dignity they felt in this process going on behind their back, essentially, and them not having the ability to consent and be as involved or engaged in such a process. There was also an element of fear of what intelligence was being gathered. Children who are victims of exploitation are already quite wary of retaliation and quite wary of how those who may be exploiting them are perceiving them. And on top of that, there is this layer of surveillance or layer of intelligence gathering that is emerging in the process of the NRM by multiple parties. And that does affect the way in which racially minoritized pupils and young people trust these adults, the level of disclosures that they make to these particular adults as well. And often there was a conflation. So children who were criminalized as perpetrators often came from the same communities or had same connections to those who were identified as victims. There was a big problem of peer-on-peer exploitation that was diluted or essentially unexplored when it came to moving forwards with an NRM referral. And there was also a big issue surrounding delays. Because of delays, there was prolonged police monitoring, there was a fear of safety, restrictions on movement, and a greater sense of low well-being and insecurity faced by those young people. And many felt that as a tool, rather than mitigating harm, the NRM often ends up reproducing harm because of the level of weight and the level of uncertainty in how data is being shared, and also the feeling of surveillance, the feeling of being watched heightens that vulnerability to re-trafficking because you feel like these adults who have been involved in your life are sort of using this to judge and make a decision about you without your consent, without your full knowledge as well. And outcomes can very much be inconsistent. Whilst there are some ways in which positive decisions can provide children with protection, often positive decisions make certain authorities feel that they can take a step back. Certainly in my own casework, I've seen that when an NRM referral is issued, the local authority says, okay, we'll disband the child protection plan, we'll disband the child in need plan, because perhaps the NRM facilitates certain interventions for that child, but that's not the case. It's adults who, under the NRM, who have entitlements to certain compensation and certain interventions. Young people under the NRM don't have access to additional interventions or support. So that remains a problem. So a lot of authorities or organisations assume we can strip back our support, or we can sort of conclude the process with that young person, given that there is a formal decision of reasonable grounds or conclusive grounds, and there's an NRM in place. The NRM doesn't facilitate any additional support. It just gives that visibility within the institution, within a system. So that can be very difficult as well. And often, if there is a negative decision, that can leave children without protection. And also, a lot of the time, Black British boys in particular, and children who are foreign national are often framed as criminals. They're often made to feel like as they're going through this process, they're abusing the system, or they're not really perfect victims who are entitled to that support and entitled to that protection. So I really urge all of you to read up on that research. It has more insight as to what the recommendations and actions look like in addressing the disproportionate impact of NRM referrals. So where do school exclusions come into this? Moving on to the next slide. School exclusions, they don't really help. As all of you may be familiar with, they don't really help in stopping the experience of exploitation that young person is facing. They are a gateway into deeper criminalisation for children who are already under surveillance from school or from bad faith actors like those exploiters. Exclusion removes one of the few protective institutions in their life. And there's a lot of children, in some casework that I do, a lot of children are engineered into believing that being out of school would be better for them because they have more time to be free and do what they want. A lot of them proudly proclaim, oh, I'm a NEET, or I've been told that it's good to be a NEET because I can then do what I want, or I can be involved in doing things that make me happy, and education is not really as important because they've been groomed into believing that a certain lifestyle is much more useful than being educated. So it doesn't help in mitigating against the school to surveillance pipeline. It doesn't help in stopping the rise of the school to prison pipeline. The issuing of a school exclusion just enables further harm. And disciplinary responses at a school level, whilst they may accompany safeguarding interventions, whilst they may preclude safeguarding interventions, they allow for interventions that are more police-led, that are more coercive, that lack consent, that perhaps are more disproportionate towards marginalised children and children of colour. And this dynamic was exemplified more in the case that we did together in RWU, because exclusion did not help the child, you know. Exclusion enforced the school to prison pipeline further, and for that child being out of school, despite being a very bright child, it completely disrupted his prospects of academic success, his focus on education as a pathway towards perhaps removing himself from those who were criminalising him and exploiting him. So when we look at case law, going on to the next slide, please. Thank you so much. When we look at case law does show, and you can look at this further online. Case law does show that there is a plethora of risks and plethora of consequences if you do exclude a child, and if you reasonably know or ought to have known they are at risk of exploitation. However, the series of case law that we've seen in child criminal exploitation and school exclusions at the moment shows that when it comes to schools, there's more of a leniency, or there is more acceptability on the court's part that schools may not necessarily have all that knowledge or all that information to have acted sooner or have been aware, and it's still maintained that exclusions are not necessarily unlawful, and we still need to consider paragraph 11 of the statutory guidance and the serious harm test, and how this potential child could seriously harm the safeguarding well-being of the wider school community. And it's a shame that in case law, courts are not seeing it the way that we are seeing it, but it still presents a possibility. Every rejection is a redirection. So it doesn't remove the preventative dimension of Article 4 ECHR. It doesn't take away the fact that schools do have the ability to hold relevant institutional memory, knowledge, system and practices surrounding that child, surrounding pastoral interventions, surrounding records like CPOMS logs, surrounding safety plans, pastoral support plans that may have been put in place in association with risks that may have been identified. And it doesn't take away that there is a review process at school level where they can make a MASH referral or where they can engage through a multi-agency approach with the local authority and be involved in those safeguarding decisions made in child protection meetings, child in need plan meetings. So whilst there is a narrowing of ambition, there isn't a narrowing of possibility. And we have seen other case law as well. So if we move forwards, and thank you so much to Ollie for highlighting these cases to me. So while CM also does not kind of build further liability or kind of responsibility towards schools in addressing exploitation concerns at school level, it does adopt the test of RWU. It does say that we do reject hindsight, and it does need to be framed around were those exploitation concerns something that the school was aware of at the moment in which they issued the exclusion. And it does adopt the framing that exclusions as a whole cannot be considered unlawful. There's still a case for them, but it doesn't mean that an exclusion will increase vulnerability, that the schools cannot assume exploitation from difficult behaviour. And if there are later discoveries that are made, they cannot be used with hindsight. And we also need to be mindful of the statutory exclusion framework. And whilst it narrows that, the case against a local authority in NAA, if we go on to the next page, it presents some opportunity. It presents some opportunity because it goes to show that there are positive duties on local authorities to act on trafficking indicators. There does need to be a greater level of communication that the local authority takes when there is information surrounding exploitation and trafficking, and a failure to communicate does amount to a breach. And it does show that you don't need to prove the outcome would have been different, but there does need to be a consideration and understanding of failures like communication and poor coordination, and that information sharing in serious safeguarding cases like child criminal exploitation can breach Article 4 ECHR or can engage Article 4 ECHR, even if disciplinary decisions like exclusions are deemed as lawful. It's still a failure on the part of the local authority if that context and information is not being communicated on an ongoing basis. So yes, there's been a narrowing of the ambition, but there's still possibilities and nuggets of information we can take from this case law to move forwards potentially with other strategic litigation challenges. So what is the litigation task following this case law? Well, going on to the next slide, I say that, yes, there's been a rejection of hindsight reasoning. Yes, they say that an exclusion doesn't necessarily, they don't necessarily believe that it can show up as making a child more vulnerable. However, there is still a possibility because there's still that preventative dimension of Article 4. There's still the importance of understanding what is that institutional memory? How can we go back and trace the records in terms of the CPOM logs, the policy in the school, the record of communication between the designated safeguarding lead and social workers? What is the record of communication involving parents and a child in school meetings? Are there reintegration meeting minutes? So you can still argue that there is a greater level of scrutiny on schools to make sure that they have systems in place and local authorities have communication processes in place, and there is a multi-agency approach in place to protect victims of child criminal exploitation and to ensure that any decision that is made in relation to exclusion does take on board that wider context. And perhaps that can be an avenue in which we push and take things forwards. So moving on to, I think if we move on to the next slide, Sophie, it's on the Children's Wellbeing in Schools Bill. So there is potentially an opportunity here because this legislation attempts to build a stronger safeguarding infrastructure and it would like to ultimately improve information sharing between local authorities and schools. And perhaps this is an avenue in which we can achieve clearer accountability within education settings in situations like CCE. So some of the provisions of this bill speak about setting up multi-agency child protection teams. So those teams would include a person with education experience, local authorities, and the local authority would also retain the discretion to include additional people as part of this multi-agency team. This would perhaps make it harder for education bodies to argue that they have a lack of access to safeguarding intelligence, because it shows that there's this multi-agency approach happening in real time. There is shared knowledge or shared accountability happening in real time. So that is a provision at the moment that is being tabled as part of this bill. And then there is also some other provisions being introduced or proposed as well. So this idea for having a single unique identifier for children, that is being contested at the moment because a lot of people feel that extends the level of surveillance that children in situations such as this already face. They may already be known to certain institutions. They may already have an NRM decision. So imposing a single unique identifier, will that just add to the level of surveillance that they feel and the lack of consent that they feel as well? There is an intention that it will allow for more joint up information sharing, more interagency interaction, but a lot of policymakers and campaigners are arguing, yes, it's important to have a joint up approach, but not at the expense of the agency and consent and the dignity of children and young people themselves. So to what extent having something like this would be useful is being questioned at the moment by organisations like the Traveller Movement, who speak about how things like having a register for children not in school, which is overseen by the local authority, would disproportionately disadvantage or discriminate against Roma, Gypsy and Traveller community children. So whilst there is this idea to build information sharing and build a multi-agency approach, to what extent does it really safeguard and protect the rights of children? That is in contention at the moment. The bill is, I think, at report stage in the House of Lords. So maybe that could be an avenue in the future which could be used to bring forth further legal challenges. So going on to the next page, last page, what more can be done? We need to reframe school exclusions. I appreciate that the case law kind of narrows the responsibility or narrows the kind of discretion of the schools, but exclusion is still a serious safeguarding event. And when I go into governing body meetings, I make it clear. And I think it's just sort of pushing that it is, when we think about the proportionality exercise, we do need to consider the way in which it disproportionately affects that child. And we use briefings like the briefings Just for Kids Law have done on the link between exploitation and exclusion. We use briefings that the Youth Legal Justice Centre have done on this issue. And we use, for example, Kainde, Black Equity Organisation submissions or evidence as well. We kind of arm ourselves with as much evidence as possible to sort of use that proportionality argument at these hearings to reframe exclusion as a serious safeguarding issue, particularly for children at risk or known to be exploited. We need to treat repeated exclusions and send indicators and other indicators as triggers for inquiry. So yes, duty to notify is there, but what duty of inquiry have these schools followed? What are ways in which, based on that context, based on knowing this child for a long time and having those communication records and safeguarding logs, what have they done to have a sense of, I would say, curiosity or insight into what more could be done to mitigate harm or support that child? I think that's something that we can be doing at an earlier stage in order to address the needs of children and young people. Also, we just need to be mindful of racialized interpretations of behavior. ways in which certain tools and frameworks that we use are not necessarily neutral safeguarding frameworks. They do, in effect, criminalise or may sort of target Black and minoritized children and obscure their victimhood and the impact of their exploitation as well. And how can we continually use Equality Act and the public sector equality duties to expose these harms further as well? Because as I've spoken to you about in this presentation, the research and data shows that it is children of colour, marginalised children are more likely to experience a referral to the NRM, male children are more likely to experience a referral to the NRM. Are there particular angles that can be explored via the Equality Act to make a case and to support in protecting these children from being excluded? And what can be done to sort of make sure that information recording is consistent within schools? At the moment, the CPOMS logs are not neutral either. Those are based on teachers' inferences or interpretations. Safeguarding communications and minutes of meetings, they're in the language or in the narrative of what the teachers perceive. A lot of the information and evidence received from schools are framed under the perspective from the senior leadership team or from the teachers themselves. So to what extent are there objective forms of evidence or sources of evidence that we can draw upon to identify risks, to challenge us at an earlier stage, to enable positive outcomes? So that's what I thought of, but everyone else might have different opinions or questions as well. Thank you so much for your time.
Thank you so much. That is an amazing breadth of presentation covering a really important topic that is, I'm sure, something that each and every practitioner in this room and joining us virtually online has come across. It is 7:30 and I promised everyone that we would finish at 7:30, so you have done so in a timely fashion. It means we haven't got more time to interrogate the topics that you have very helpfully brought to the table. I think that the discussions will have to continue after this webinar, so I want to thank all three speakers. I know that Sharon is just having to leave now, so thank you so much, Sharon, for joining us. Thank you also to Olivia Hammond, who is still here. Oh, Sharon is still here. So thank you both indeed for your presentations. It was a really thoroughly stimulating discussion and has left everybody with a lot of thought-provoking questions to answer and explore and interrogate. Thank you also to Aqsa Suleman, who's in the room here today. So thank you all for coming. We will continue the discussion over refreshments. There's one question in the room. We'll continue the discussions over refreshments. We'll share the presentation with you, and we can all use the network that already exists to continue the discussion. But I have one final contribution from the room.
Sharon, thank you so much. I just really wanted to share the fact that the Milburn inquiry into youth inactivity, which I'm sure a lot of the colleagues in the room are aware of, is taking its submissions this week. The deadline is Friday. If anybody is interested in that and in communicating with me about that, I'm coordinating a response from a particular group in Suffolk. And it's important work, and there's also a working pension select committee.
I think that's really helpful because it's another way beyond strategic litigation in which that you can influence policy in its formation and inquiries into issues. So thank you so much for sharing that, and we will make sure that everybody gets the details in order to be able to contribute. And with that, I thank everybody very much.